here. The other case can set up. It's RAGHUVIR versus Department of Transportation. I hope I'm pronouncing. How do you pronounce the? RAGHUVIR. Okay. Thank you very much. Let me work on this clock just a minute. Okay.
Good morning, Your Honor.
Okay, you'll have each side, in this case, we'll have 20 minutes.
Okay.
All right.
I'd like Joseph Handwriting, the firm Foreman Handwriting Montgomery. I'd like to reserve 5 minutes.
Okay.
I'm here on behalf of the appellant, RAGHUVIR Foods, who is the respondent below in an eminent domain case. RAGHUVIR Food was a tenant on a property that had a partial acquisition of land for a condemnation proceeding for a road widening on State Road 35 in Marion County. The property was occupied with a convenience store with gas sales. As a result of the acquisition, the property lost its gas area. All parties agreed that the property was substantially damaged as a result of the taking, that the property owner had met the statutory criteria for being there 5 years prior.
Let me ask some questions about 73.015(2)(c) and how we should interpret this particular statute if we find that it's not clear and that there's some ambiguity here. And so I'll be. Do you have the statute before you?
Yes.
All right. So I'll begin with the part of the statute that has to do with the business owner must, within 180 days after either receipt of the notice or date of the notice is returned. And then it goes on to say that submit to the condemning authority a good faith written offer to settle.
Correct.
All right, and then we go down a little bit further, and it says, absent a showing of a good faith justification for the failure to submit a business damage offer within 180 days, the court must strike the claim. And so my question to you is, based on what was said before in the prior sentence, describing the offer as a good faith written offer, and then we go down to the second sentence, which requires that they submit a business damage offer. Why wouldn't it be reasonable for us to say that what they're talking about is a good faith business damage offer? Because
this court, as recently as McMurr versus Marion County, had held that in interpreting a statute, the legislature's omission of the words good faith prior to the word business damage in the second part of the statute is an intent on their part not to require that as part of the criteria. My question to you is, they've already said that it must be a good faith written offer. They've already defined it. They define it as a good faith written offer for purposes of what you need to submit to the Department of Transportation in order to negotiate. However, when they put in the provisions that pertain to striking the offer, they omit the use. And how does that even make sense? And that would allow, any ridiculous, absurd offer be made as long as it's within the 180 days, then it can't be stricken. That doesn't make any sense. Because the statute was provided for purposes of giving the Department of Transportation the information they needed to make an active, to assess a good faith offer to settle business damage claims. And it was a good faith offer to settle the business damage claims. When the offer is made, we're saying we're offering to settle this in this amount in good faith to resolve the case. And here's the information that we provided. If it's subsequently determined that the information, the financial information that's provided is lacking in some way or another, then the statute has another provision which pertains to the determination of attorney's fees. And that's where the failure to submit the appropriate or good faith information relevant to the offer comes into play. Let's assume for purposes of argument that you're correct and we buy that analysis of this particular statute. I have a hard time with that analysis, but let's just assume that we say that's what the legislature meant and that's what this says. And the statute gives the trial judge the authority to strike the claim if it's not timely.
simply because the statute gives the authority to strike the claim if it's not timely, why does that prevent the trial court from striking the claim if it's not made in good faith?
Because the legislature did not give them the authority to strike it for any other reason than being untimely.
But if the legislature didn't, if the legislature gave them authority to strike it for one purpose, why does that necessarily mean that the court is prohibited from striking it for any other purpose?
Because the statute went on in 73.01505 to say evidence of negotiation or any written or oral statements used in mediation or negotiations between the party under this section is inadmissible in any condemnation proceeding except for a proceeding for determining attorney's fees. So the legislature specifically locked it in, saying we want you to give the condemning authority a business damage claim prior to litigation commencing and give them the financial information they need to ascertain whether or not that
then what significance then, or what does the good faith written requirement mean then? I mean, it virtually becomes meaningless then, doesn't it?
It doesn't become meaningless. It has meaning in terms of that the business owner would be willing to settle for the amount of money that they're offering to settle. If they fail to provide any information, and it's our position that below that there was a mistake with regards to the financial or the sloppy record keeping, but they provided no information whatsoever, then the only impact in terms of the analysis of the good faith is the calculation of attorney's fees when subsequent financial information.
Okay, when then does the good faith written offer have to be made? Now, we know that they have to make a business damage offer within 180 days. You're saying that's something different than the good faith written offer. When does the good faith written offer have to be made then?
In terms of the business damages?
When does the good faith written offer have to be made to the condemning authority?
That must be made within 180 days after the notice to the property owner that their property is going to be taken for condemnation.
So what's the definition of a good faith written offer?
In my opinion, a good faith written offer.
Actually, I was hoping for someone else's opinion.
I believe that the statute doesn't define, nor is anywhere does it define what a good faith written offer is.
No cases on the definition of what a good faith written offer is in this context.
Not in this context. This is a case of first impression with regards to
And do I correctly understand your position on appeal to be you're not arguing that this was a good faith offer? You're simply arguing it didn't have to be. There's nowhere that you argue there was insufficient evidence to show that it was not in good faith, et cetera, correct?
For our purpose of argument, yes, it does. For purposes of striking the claim, it doesn't have to be a good faith written offer. It has to be an offer that is made within 180 days.
Your argument is it was improper to strike it because you can't strike it even if it's not in good faith. You're not arguing they shouldn't have stricken it because it was in good faith.
Correct. And as a strict instruction of the statute, that the statute itself.
How's a judge supposed to determine what good faith means?
Well, the purpose of the statute is limited solely for the time frame of pre-suit negotiation.
Well, I'm sure it's similar to the med-mal mediation statute or the offer of judgment statute for that matter. But if there's a written offer made within the 180 days, what criteria does the trial judge use to determine whether that is a good faith written offer?
I think the trial judge is only entitled to determine whether or not that offer was made within 180 days if he's going to decide to strike the claim.
Your argument
What's the point of having the words good faith in front of written offers?
Well, the good faith is that the property owner would settle the case in good faith. He's making an offer of settlement in good faith to resolve the case prior to suit.
You're saying the good faith means that's a number I'll settle for?
Correct.
So the good faith offer could be, give me $1 billion. I have no documents to support it. I want $1 billion. That's a good faith offer.
At which time the statute says the department does not have to respond to that offer, but can request additional financial information. If that financial information is provided, then they're entitled to base their determination of what the attorney's fees would be based upon the submission of the financial information needed to support that offer.
But
if it's not made in good faith, then they can attack the attorney's fees.
But that would be a good faith written offer.
It would not be a good faith written offer. No, it would be a written offer that would be subject to the Department of Transportation's opportunity to scrutinize that offer as provided under 73.092.
Your argument is they can make any written offer that they want to, no matter how absurd or no matter how ridiculous. It doesn't have to be good faith. It doesn't have to be bad faith. Good faith doesn't matter. As long as they make it within 180 days, that's sufficient. The trial judge can't strike it, and they have to proceed with the hearing.
That's only for purposes of pre-suit litigation. That is not for purposes of trial. That offer is not binding on their position at trial.
Let me go back to finish my line of questioning. We have a 180-day time limit for the good faith offer, and then we have a 180-day time limit in the second sentence that has to do with the business damage offer. Why can't we say that that's even more evidence of legislative intent, that what they meant when they said business damage offer was the good faith written offer? They both have the same time limits. They both have to be submitted within 180 days. Well, I mean, why can't we say that based on what was said in the prior sentence and in the subsequent sentence, what the legislative intent is that the trial court can strike a written offer if it's not made in good faith within 180 days?
Because the rules of construction of the statute say if the legislature omitted a term in a subsequent portion of the statute, it's deemed to be intentionally omitted.
What are the consequences, if any, of failing to submit a good faith offer within 180 days?
If the consequences for failing to submit an offer within 180 days.
A good faith offer.
The consequences for failing to submit a good faith offer is that after the department has an opportunity to review the financial records and determine that it is not made in good faith, they are entitled or obtain the financial records necessary and material to making a determination as to whether or not the offer was made in good faith. They can then resort to making a counteroffer based upon the submission of the subsequently required documents to determine what a good faith offer was in order to make a counteroffer in order to eliminate the attorney's fees, because that's essentially what the purpose of the statute is. So number one,
I didn't follow you. The consequences are you can make a counteroffer?
The condemning authority then has the right to not make a business damage offer at that time, all right, and then to request the financial information they need that they deem material in order to evaluate the initial offer, and then thereby make a counteroffer which would affect the amount of attorney's fees that are allowed under 73.092. So if the offer fails because of lack of information or inadequate information or inaccurate information, the condemning authority has provided a mechanism within 73.092, which is the only purposes for which under paragraph 5 of 73015, for which you can look at.
Let's assume for purposes of argument only that we say that, the trial judge does have the authority to strike an offer if it's not a good faith written offer. Let's just assume that for purposes of argument. I'm not saying that's how we're going to rule. Is it your argument that what the offer that was made is a good faith was a good faith offer?
We believe the offer that was made in good faith. It was made based upon inaccurate financial information that was subsequently determined.
Okay, now my next question is, the issue as to whether an offer is a good faith offer, is that an issue of fact or is that an issue of law?
I would believe that would be an issue of fact.
Right.
And I believe.
Now here's what's bothering me, because the trial judge in this particular case made lots of findings, didn't he?
Yes, he did.
And one of the statements that he made was basically a statement to this court. And he said, and the Fifth District Court of Appeals may tell me that I'm all wet, but my only comment is that if you could see the witnesses and their demeanor, experience the frustration of the department's representatives in trying to pin somebody down, and watching the demeanor and the mannerisms of the real party in interest here, the business owner, there would be no question as to an understanding of a lack of good faith. And that, coupled with the other findings that the trial court made, gives me some, and you can see it's basically a factual issue, and I think the trial judge went through, a hearing that lasted a day or two, heard evidence and testimony, and based on his judgment of the demeanor of the witnesses and his looking at the evidence and is judging the credibility of the evidence, made all these findings of fact. What are we supposed to do with those findings other than to say that there's substantial competent evidence to support them and conclude that this was not a good faith offer?
Our argument is that at that stage of the proceeding, we should have been heading for trial. This probably would have been more appropriate for a motion in limine, not a motion to strike for failure to submit an offer within 180 days. Again, the Department of Transportation had already been provided the documentation. We gave them over a year, and they only had 120 days. We gave them a year, free access, unfettered access to our financial information and our client to ascertain what the facts were relevant to this offer. It was based upon a mistake, is what our basis is.
Well, it was
But
based upon-
regardless of that
I mean,
fact,
the trial judge had some concerns about it to begin with, and then said that, you know, this is not sufficient, gave you, 90 days or some period of time to come up with what he considered, what everybody would consider to be a good faith offer, which would be an offer that calculated the damages based on uncommingled bank records. And the trial judge, I think, got frustrated, and so did the other side, because there was really no real bona fide attempt to uncommingle the bank records from one store from the other.
we disagree with that. We believe that there was a bona fide attempt to uncommingle the funds from one side to the
The
other.
trial judge didn't think
The
so.
trial judge didn't think so, but we believe there was. And the fact of the matter was, our position was that the judge had no basis to strike the claim at that time, because the statute merely provides for striking the claim if
4 minutes left.
it's not provided within 180 days. Thank you.
I'll get you on the rebound.
Okay.
May it please the Court, Gregory Costas, counsel for Appalachia, Florida Department.
Can you state your last name, please?
Costas,
Okay, thank you.
C-O-S-T-A-S.
So what's the definition of good faith?
There's no definition in the statute.
Then how can a trial judge apply it?
Well, a trial judge can look at the totality of the circumstances that are before him and make a determination whether the party is acting in a reasonable manner. And
Tell me one situation that you can possibly think of in a pre-suit circumstance where a trial judge is required to make credibility determinations like that.
In this particular statute, where the legislature has put the requirement in there that the offer has to be in good faith, and if a good faith offer is not submitted, then
So what's the
landowner's
landowner?
damage claim is subject to be stricken. And Judge, one thing we've got to consider, first of all here, the posture that this appeal is in when we're looking at the issues before the court. You had a trial judge that went through an evidentiary hearing.
Yeah, I'm trying to figure out why he had an evidentiary hearing.
Well, if I can just make one comment, I think we can get to that point. None of these findings have been challenged on appeal. The trial judge found that a good faith offer had never been submitted. The first offer, even the trial counsel for the business owner and their expert conceded was not a valid offer.
No. What they conceded was their numbers were wrong. That doesn't mean it wasn't a valid offer. That doesn't mean that the offer wasn't made in good faith. It just means that they had bad numbers.
Well, the trial judge has made that finding that no good faith offers were submitted, and that has not been challenged on appeal. The only thing that they've come up to this court with is a hyper-technical argument based on a construction of the statute.
Oh, I don't think it's hyper-technical at all. The statute says you get to strike it if it doesn't show up within 180 days. That's all it says.
And the trial judge concluded that a good faith offer had never been submitted.
How could anybody tell what a good faith offer is if there's – how can the landowner know what a good faith offer is?
Well, you give somebody an offer that's based on reasonable numbers. This gentleman had a number of corporations.
Because there's a dispute between accountants? I mean, suppose this guy kept no records at all. Suppose he had three stores, an individual, 3 stores. The only thing he reports is one income tax return covering all 3 stores. And one store is condemned. Are you telling me that for that reason, that person can never have a good faith offer?
You have a good faith offer if he indicates that the stuff's been commingled
Well, that's what happened here. It was commingled.
And that did not come out when the initial offer was made. It was by virtue of the department continuing to ask for information
So does sloppy bookkeeping amount to bad faith?
under circumstances where it should have been disclosed, absolutely. But again, you don't get to that point because nobody, the landowner, has not challenged any of the trial judge's findings on this issue.
I'm a little bit puzzled here because the statute says the business owner must, it's mandatory, within 180 days, submit a good faith written offer. How is the trial judge supposed to determine whether that has been complied with unless the trial judge holds a hearing to determine whether a good faith offer has been made, as the trial judge did in this particular case? Doesn't the statute basically contemplate that if it's not filed within 180 days, or it must be filed within 180 days, and it must be a good faith written offer? Doesn't that contemplate that the trial judge must hold a hearing and make some findings as to whether it's a good faith offer or not?
Well, yeah, absolutely, because you get that also from the language in the statute that says you're going to strike the business damage claim for
In this particular case, they held a 2-day hearing. Was it 2 days or 1 day? I don't really recall, but it was a rather lengthy hearing, wasn't it?
200 pages of transcript.
And the trial judge gave them 2 opportunities to uncommingle the funds between bank accounts so that the department and the trial judge could determine whether this was a good faith offer that allowed them to claim $800 and some thousand in business damages from a business that had commingled funds from another business that was supposedly a better store, doing much better, making much more money than the store that the department was seeking to condemn. Isn't that basically what happened?
Yes, sir.
And they didn't comply with that. They came back with an offer of $700,000, and the trial judge determined that they had not properly uncommingled. I mean, I'm having a difficult time with the thought that, how is a trial judge supposed to make a determination whether this is good faith or not unless he holds a hearing and listens to evidence and testimony?
Well, I think that's what the statute contemplates when it says the trial judge will strike the claim if it hasn't been, the good faith offer hasn't been timely submitted.
No, it doesn't say that.
Well, I understand.
It says absent a showing of a good faith justification for the failure to submit a business damage offer. It doesn't say anything.
Okay, so then, Your Honor, you suggest that the offer can be any kind of bogus offer and that satisfies the requirement?
We
legislature
allow insurance companies in mediation cases to offer $1 in settlement of the case.
Well, that's not what the statute is saying here.
Like they're supposed to be acting in good faith there too. I mean, what it seems to me that what happened here is the trial judge made a credibility determination about the quality of the accountants involved in this and struck the damages. That seems to me to be a determination of the jury.
Well, he also made a determination as to the credibility of the landowner in his testimony. And again, that hasn't been challenged on appeal.
Well,
The trial judge's findings haven't been challenged, Your Honor.
Yeah, I understand that, but the statute doesn't say that if you fail to submit a good faith offer, it says if you fail to submit an offer within 180 days.
So any offer would do, notwithstanding the fact that up front in the statute it identified the business damage.
And what's the harm of it? What's the harm of that, Mr. Costas?
What's the harm in letting any offer come in?
Well, the harm is that the landowner doesn't get big attorney's fees.
The attorney's fees goes to the timely submission of the records. It has nothing to do with whether or not a good faith offer has been made. That whole scenario is tied to whether or not records were produced, and that's not the issue here. Nobody's claiming about the production of records.
If you can't,
they're complaining about the good faith effort.
If you can't produce good records, then your offer is not going to be accepted by the Department of Transportation in any event. So it all weaves back to what sort of attorney's fees. See, I'm bothered by the notion that the legislature has authorized landowners to get business damages under the circumstances described in the statute, and yet we are short-circuiting that by having a trial court determine that the offer was not made in good faith at the outset of the case. It seems to me that juries make that determination. If a jury decides that the records are crummy, it seems to me that that's the way that ought to come down.
Well,
If that's the case, then what significance is it 180 days? I guess he and I are basically arguing amongst ourselves through you, but my question to you is, if the jury's supposed to decide it, what significance is the 180-day requirement, that it be made within 180 days, the good faith offer be made within 180 days?
Well, first of all, that 180 days is probably going to expire before you even have a suit filed, so there's not going to be a judge or jury or anybody else to be considering that. And the vehicle the legislature's provided is obviously a motion to strike. It'll be brought after the suit's been filed when you have a forum that you're before.
Show me where the legislature has provided that.
When it says that you can strike the business damage claim.
No, it says absent a showing of good faith justification for the failure to submit the business damage offer. It doesn't say you get to strike it for a bad faith written offer. It says absent a failure to submit the offer. I mean, it seems to me this is something to get settlement negotiations
If it's a
started.
bad faith offer, then why do you have the requirement that it's good faith? Judge, for them to prevail on this record with the trial judge's findings intact, which haven't been challenged, you essentially have to hold that the submission of what the trial judge has found to be not a good faith effort satisfies the legislature's requirement to submit a good faith offer on business damages.
I guess the problem that I'm having, Mr. I understand.
No,
I'm really struggling with how you tell a landowner whose property is about to be taken, I want you to have a good faith offer given to me. Good faith written offer. And it seems to me that if you're about to take my land, I'm going to give you an offer that I would willingly take. I don't know what the definition in this statute of a good faith written offer is, but I suppose I would say that's a number that I would take in settlement if we're going to settle the case right now. And then you get the opportunity to respond, and I think this is an attempt to get negotiations started. That's all. I don't think it was ever intended to short circuit. We're real proud of the right to jury trials for condemnation cases in this state. We give them 12-person juries.
Well, I don't dispute that, and rightfully so. I mean, that's the way it should be. A person's property is a very substantial interest. Of course. Business damages, on the other hand, are purely a matter of legislative largesse and is purely a statutory thing. So I don't want to mix the two. Those are two.
Would you say that it's a condition precedent to obtain these sorts of damages that the landowner submit a good faith written offer within 180 days pursuant to the statute? Is that considered a condition precedent to obtaining those damages, or if it's not a condition precedent, what would it be?
One problem I have with calling it absolutely condition precedent is there's the language in there about or at a later time mutually agreed to by the condemning authority and the business owner. So that leaves
That would kind of leave open the fluctuation of 180 days if they wanted to, but that doesn't alleviate a good faith offer, does it?
Yeah, but that aside, I think you have to come forward with a good faith offer, because if you don't, you stand the risk of having the claim at trial stricken. We're not talking about striking the offer.
Well, see,
We're
claim
talking
at trial,
about striking the claim.
I got no problem with striking it at trial. I got no, if the expert testimony is incompetent, I got no problem with striking it. What's the business damage statute?
73. Oh wow, this is pretty soon.
015?
015 is pretty soon. Yeah.
That's what I'm looking for. 071?
It's business and good standing for 5 years.
Okay.
No, forgot to introduce Mr. Lassman. He's a trial lawyer for the council. That's the
Hi.
department of law.
Oh, hey, Harold, how you doing? My gosh, I haven't seen you in a long time. You gained weight. Where less than the entire property is sought to be appropriated, any damages to the remainder caused by the taking, including when the action by the Department of Transportation, et cetera, and the effect of the taking of the property involved may damage or destroy an established business of more than 4 years standing. 5 years standing. See, I don't read anything in there that says you got to have a good faith written offer.
Yes,
as
because
a condition, as a condition
put in
proceeding.
73015.
Now, this is the one that describes where you get business damages. I don't see a condition proceeding.
Well, they put that in there as a sanction for not complying with the pre-suit negotiations that they've set out. It's the way the legislature's dealt with. I mean, they could have made this under that particular section they did, and they set up a separate pre-suit negotiations statute. The intent behind this is to encourage settlement. I don't think anybody disputes that.
What's your definition of what is a good faith written offer? What makes it good faith or not good faith?
It has to be based on reasonably decent data supporting the offer, reliable data. And that was the problem in this case. The data
And
wasn't
so
reliable.
anytime the other side, through cross-examination or countervailing experts, can undermine the reliability of the numbers, it no longer is a good faith offer?
I think once you get to the point where you proceeded to trial, you've probably gotten past the point where you can argue that any problems with a good faith offer. All this was done pre-trial. I think.
But in the course of pretrial depositions, you've got countervailing experts who say this number's unreliable for this reason. Or you cross-examine the expert for the business owner and they can see they've made some mistake in the numbers. Does that convert it into no longer being a good faith offer? Because there is some discrepancy in the numbers, or does it take more than that?
I think in this, well, the facts of this case, there was more than that. The trial
The
judge.
question is, in the abstract, does it require more than that? Or simply, is it your position that if the numbers are undermined along the way, you can now say it's no longer a good faith offer because the numbers aren't reliable?
Okay, well, at what point in time? Because
At the point in time when somebody moves to strike it to keep it from getting to a jury.
Okay, well, are you saying pre-trial or in the course of trial? I mean, because I think
Got to be
I think there might
pre-trial.
be a
See, this was done pre-trial, right?
Correct.
So pre-trial, discovery's done, and now you think the numbers that were provided were not reliable. Is that enough to get it stricken as being no longer in good faith because I've now got evidence to show the numbers aren't reliable?
The evidence shows that it was the type of situation you have here where the numbers are not reliable and where the evidence has been withheld and it's a changing target throughout the course of proceedings, yeah. Because you've got the totality of the circumstances that are involved and it's starting to sound like a criminal case, but it's the same concept. You've got, first of all the commingled corporations, the continuing moving target. I mean, the whole intent of the statute, or one of the major intents, is to provide the condemning authority with a reasonable basis to settle a claim, to come forward with a reliable offer. Mr. Gerson's testimony in this case about the business that happened with a tax return, it's a classic example of the kind of evil this thing would address, because he said, having received that tax return with all the indicia, it was a final filed tax return, he would have been prepared to go forward and award business damages based on that return. Then he finds out the return's off by $60,000, and it's still a moving target. So those are the types of things that I think the good faith requirement is in there to remedy.
Mr. Costas, Mr. Lasky, he seems desperate to talk to you. He's fidgeting rather badly. Go talk.
Yeah, go ahead. I'll give you a short break. Give you 4 minutes when you start back.
Okay, that was a bad idea. I'm sorry.
Judge Palmer, where were we?
He was wanting to know how do you determine what's a good faith offer?
And I think you answered that question for me.
You were talking about the tax return that he submitted, a tax return that wasn't even a final return. They discovered that it wasn't a final, and they had to
And
go
it
back.
was submitted with indicia that would lead one to believe that it was a final return. And again, the trial judge's order is replete with these circumstances. I can say that the facts of this case would definitely fit anybody's definition of bad faith. Now, what you
Could
can
the
do-
court have stricken this damage claim under its inherent authority, under the rules that cover things like discovery, you know, when they determine that you haven't answered interrogatories accurately, you haven't provided, the court has some inherent authority in those cases to strike various claims. Could that, does this rise to that level in your mind, that the court could have done it in this case? Because in essence, they were
conceivably.
presenting fraudulent testimony?
Yeah, conceivably, but he had a specific statute to operate under, so I think it's an even stronger position. And, you know, we've been talking a little bit about statutory construction here. One of the foremost maxims of statutory construction is you don't interpret a statute to get an absurd result. And again, given the trial judge's finding here, you would be holding that submission of a bad faith offer satisfied the requirement to submit a good faith offer. One other point I want to make, there's been some argument based on section 730155 about the confidentiality requirements. That was never raised below as any type of objection to admission of any testimony, and in fact made its appearance before this court for the first time in reply to. So I would submit to that argument it's not properly before the court. And let me just make sure I did everything.
You're not aware of any cases that have actually interpreted this particular statute, are you?
No, sir.
Do you think that this would be a case of great public importance that perhaps the Supreme Court should take a look at, that we should certify a question of great public importance, that, you know, as to what the statute means?
99 times out of 100, Judge, I'd be glad for you to do that. At this time, I'm not, you know, yes, I think it is an important question.
Okay.
And, it, you know, it possibly, the statute might need a little clarification from either the Supreme Court or the legislature.
So it's an important question, but not necessarily a great question. Is that what you're saying?
I'd just be happy to prevail, Judge. I mean, you know, but no, seriously, you know, yeah, it's got the very great likelihood of recurring, so that might lend itself to that type of.
Your time's expired. Thank you.
Thank you very much.
And I think you had 4 minutes left.
Thank you, Your Honor.
You need to consult with Mr. Lasky first.
No, I was a trial attorney as well, so. Thank you. With regards to this is a pre-negotiation, pre-suit negotiation statute that was created by the legislature to affect the situation where prior to the effection of this statute, there was no negotiations pre-suit. The condemning authority was not given access to documents because we had the whole take statute. Part of the
Had your client made an offer of $2 billion, that would be something that the trial court would just have to say, well, let the jury decide?
Well, no. If we went to trial and then we're at trial, then we're at a different level of anticipation. Evidence is coming in.
Within 180 days, you must submit a good faith written offer. And I'm trying to make some sense as to what that means, and I think you basically understand where I'm coming from. My question to you, and I think Judge Palmer may have asked this before too, you submit an offer, let's say of $2 billion, and that's a good faith written offer made within 180 days, according to your argument.
It may not necessarily be a good faith offer if you haven't based it on.
And what does the trial judge do with that? What does the department do with a bad faith written offer?
They are entitled to request the financial information that forms the basis of that pre-suit negotiated offer, for which under Chapter 5 of this, none of these proceedings are entitled to be reviewed for any other purpose other than
essentially what you're saying is that just requires that they just dig further, and it's up to them to go ahead and find the evidence and continue to make requests, and it's up to them to discover what, you know, your client was supposed to present in the first place in terms of a good faith written offer.
In this instance, we provided it. Well, if there was no business records, yes, that's what the statute contemplates. That they go ahead and make the inquiry, request the information. The only prerequisite to filing a business damage claim under the statute, in terms of it being struck, is that it not be filed within 180 days. If that's the only power that the legislature gave the trial court. The only other part I'd like to get, this was pre-suit negotiations. It was done, and the statute was enacted in an effort to create pre-suit negotiations. And I think in this instance, by having these records out long before suit was filed, and having both sides cooperating in an effort to ascertain what the true financial records and financial nature of this business was, enabled us to come to a truer picture of what's really going on. And that's why the third point of our appeal, that we be allowed, and if we are allowed to go back to trial, to look at records subsequent to 2002, the date of taking. We believe that business records subsequent to the date of taking are important. The Mulkey decision and the Weiss
I
decision.
think you got to rely on your brief for that argument, because the other side didn't raise it in their response, so there's really nothing for rebuttal purposes, and you're limited to rebuttal arguments
I
during this
apologize.
time
Thank
frame.
you, Your Honor. With
The time's
regards,
about exhausted anyway, so you got 2 seconds, so wrap it up.
with regards to, again, I would submit that this is a pre-suit negotiation statute that is there for that purpose and that purpose only. It is not to ascertain the validity of the business damage claim that goes to trial. That the business damage owner has a right to have a jury hear the evidence and have the jury decide based upon the evidence that's presented at the jury trial what the value of that business is and what the entitlements of those business damages are.
Just one other question. What remedy does the other side have if you continue to act in bad faith and continue to submit bad faith offers?
One of
Do they have a remedy at all?
the tax return was not used in any business damage claim. It was something that was requested.
That's not the answer to the brief.
I apologize. Their remedy, again, is to attack the attorney's fees based upon the ultimate rendition of the case.
So,
And that's what
so the
statute comes from.
remedy always goes back to attorney's fees.
It goes back to attorney's fees under the
Okay.
statute.
All right, thank you.
Well, I don't know about the other two judges, but I had a ball with this. Thank you all.
Okay, we're gonna, as I said before, we're gonna take a break. Please excuse me if I can't make it back to the lawyer's house. If the lawyers